Good morning, everybody. Welcome to our webinar on licensing and obtaining the best possible license for your premises. It's great to have you all with us this morning, and I'm delighted to say I'm co-hosting this webinar with my wonderful partner at Keystone, Neil McCann. My name is Gareth Hughes. I'm a barrister of 30 years standing. I've practiced in this area for many years. So I have a little bit of experience that I hope we can pass on to you today. And what we hope to do today is to look, as you've seen at the top of the webinar, the 10 ways to get the best premises license for your restaurant or your bar. And most importantly, what we've left off at the end there, I suppose, is how to do it cost effectively as well, which is very important for all of our clients, of course. So efficiency and cost effectiveness, I think, are the two key aims that we're looking at today. So brief introductions for me. Well, first of all, we hope to take about an hour today of your time. Neil and I will take about 40 minutes presenting the various topics, the 10 points that we've highlighted. And we will allow questions and answers after that or during the webinar. So please feel free to post some questions, and after each topic or every other topic, we'll try and answer those for you. Or if you're happy to wait till the end, then also feel free to do that too as the topics develop, and we'll do a mopping up exercise, questions and answers then. So feel free to send those questions in as we proceed. Just a few words about your two hosts today. I'm Gareth Hughes, as I said, 30 years experience in this area. I'm a barrister and a partner at Keystone. I have served in chambers. I have been the former deputy head of legal services at Westminster City Council, so I've seen how a local authority such as one of our leading ones operates from the inside. I've been a partner in a West End law firm for many years, Jeffrey Green Russell, and happy to say I've been a partner at Keystone now for the last 6 years. And a great firm it is too. And we have many lawyers at Keystone across a broad range of disciplines, not just licensing. So I've acted for many businesses throughout all of that period, and local authorities and police. So I've seen licensing from all aspects. And on top of all of that, I've also sat as a councillor, been elected councillor, and chaired a licensing committee, planning committee as well. So I have quite a bit of inside knowledge. And I'm also the chair of the London Region Institute of Licensing and a national director. So could I just hand over to my colleague Neil to introduce himself briefly?
Yes, thank you, Gareth, and good morning, everyone. It's always slightly embarrassing having to do your intro after Gareth because it's going to be much shorter. I'm not nearly as experienced as Gareth. I've only got approximately 20 years of experience doing licensing. But likewise, I was also a partner at a West End firm before joining Keystone just over 2 years ago, and I'm a partner there of a licensing team. In terms of the types of work I do, it's broadly similar to Gareth. I'm a licensing specialist, but I also do ancillary work such as regulatory and prosecution work related to licensed premises, and also I do some gambling work as well. But my primary focus is premises licensing. That is why I'm giving the talk today. Anyway, I think I'm going to talk to you in a bit, but Gareth, I think you're taking the first few slides. Is that right?
Yeah, thanks, Neil. I thought I'd do a brief introduction and then lead into my first couple of topics that we want to deal with today. We think these are the 10 most important topics. There will be other topics that are relevant, but Neil and I think that these are the 10 which we've distilled over our years of practice. So briefly, just to highlight, of course, the difficulties the hospitality industry has been in over the last year. I'm sure you'll be very well aware from all the news reports in the last 60 weeks or so of various lockdowns and opening ups and so on, of the difficulties that our great industry has faced. And we've seen the closure of many premises. About 9,000-10,000 pubs have gone, and a few thousand restaurants, which is very sad for all those who've operated in this industry for many years. But now on Monday the 19th, we're looking forward to the complete elimination of lockdown measures. which have been promised by Boris Johnson. We might still retain some restrictions, we hope not many, but there will be opportunities for new and existing premises, and you will need to be at the forefront of this new phase to ensure that your license is fit for purpose in the brave new world that awaits us beyond lockdown. So we think it's essential that all the preparation, all the money invested and the enthusiasm in your business and in setting up that business or changing your existing premises is not lost by the failure to secure a good operating license under the Licensing Act 2003, which will allow you to sell alcohol, supply late night refreshment, provide regulated entertainment for the hours and the capacities that you would wish in the area that you prefer. And neither do you want to end up with a license with so many conditions added to it, and we found this before many occasions in cases that we've not acted in and they've come to us later. So many conditions attached that it makes it almost useless as a license for an operator to work to, and certainly not what they'd originally intended when they had made an application for that license. So this is why it's so important to get your application for a license approved quickly and without onerous restrictions, and as I said at the beginning, in a cost-effective manner. Now, there are numerous ways in which all of your hard work beforehand can come to naught on an application which is hastily prepared or ill thought out, not presented in a professional manner, and costly. We have a saying that there's nothing more costly than a failed application. And this is because you would have expended a lot of money on experts or advisors, as well as getting your building ready for the new customers. You would have paid premiums on leases and business rates and so on. And if that goes wrong, you're in difficulties, and you could appeal a decision not to grant you a license, but this will ultimately cost you substantially greater sum. So my 30 years plus of experience in the business, Neil's 20 years, I think, Neil, as a recognised senior barrister and solicitor in this field, and dealing with thousands of these cases in all of that time, has allowed us to see where applications can go wrong from the outset. And hopefully today we want to explain to you the 10 most important issues that we see in this respect, so you can get it right, and hopefully use us in the process to assist you in that path. So it's very critical, as you can see, that you get this right from the very start. So can we just turn to the first topic that we want to deal with today, which I've headed up on this slide as knowing how to work with the local authority and experienced technical officers. Now, as you know, the process of applying for a license is submitting, in its most basic form, submitting an application form to the local licensing authority, in other words, the council in the area. And it is officers and technical experts who will then judge that application that goes in front of them. And as part of the consultation process on your application, residents will also wade in too. So you will need to understand what drives and motivates licensing officers, environmental health officers, trading standards officers, planning officers, district surveyors, as well as the police. Just had a client yesterday who put in his own application recently and told me that he couldn't believe how many various tiers of officers he had to deal with in this process. So there's a lot of people that we need to speak to and understand how they operate. So you need to understand the imperatives faced by the technicians, so you don't create unnecessary obstacles for yourselves and the application, and help smooth the process going forward. Many of my clients over the years have found this, I think, one of the most difficult parts of the whole process. They're business people, anxious to get on with their projects, and find themselves sometimes banging their heads against a brick wall, against local authority bureaucrats, shall we say, for want of a better word. Now, you'll need to know how to work with those officers and the police and understand the rules and the policies under which they operate. So we hope to explain a lot of that to you during the application process. On top of all this, you'll need to be able to work with local residents and their associations, And I may say this can often be one of the most problematic because sometimes residents are often the most hostile of all to a new or variation application because of a fear of the unknown, because they'll always assume that the noisiest bar or club is moving in very close to where they live, when in fact it could be a very innocent little small bar of 20 people, little restaurant, a cafe bar and so on. But they will always assume the worst and will put in representations against your application. So getting all of this wrong at the outset will place the whole application in jeopardy and will threaten your plans and your investment quite enormously from an early stage, and the money is lost. So in that respect, how can we help? Well, we've got years of experience of dealing with officers, police, councillors and so on. I told you about my experience at the top of the webinar. And I think that using our services means that we can put together and build up a detailed operating schedule for you, which of course is a requirement of an application going in, and a management plan as well at an early stage to discuss all of this with the officers and the police and convince them of the professional nature of the application that's being submitted. We work closely, we'll work closely with you on bringing the schedule together and the policies you need to support that. And I've worked myself with so many of the relevant officers, particularly in London, but also in a lot of the local authorities around the country, and have very good relationships with them all. And that has often assisted clients greatly, helped many clients to clear the pathway to obtaining a very good premises license. And I also know many of the relevant experts, and we'll look at these a little later, to bring in, as does Neil, and should they be required to be called upon to give your application that professional gloss that it will need in order to impress the local authority. So that's hopefully step one that you will need to address in framing the application and submitting it. On step two, the next slide up, you need to have, I think, regard to the legal complexities for restaurant and bar applications and get those sorted right from the very start. Now, the operating schedule that accompanies all the applications in the country needs to be a professional document, as the application will swiftly run into buffers without that document. And again, I've had recent experience of clients who've come to me having invested significant sums of money only very recently in the adaptation of a farmhouses and outhouses for a wedding venue, completely converting the use of the farm into that use. And they've gone through a very long process of obtaining planning permission. They've achieved all the health and safety requirements that they need to. Food standards have had a look at their application. It's gone through a rigorous process, and they left the licensing process to the very last minute, and they've stuck a form in without any accompanying management schedule, operating schedules and so on. And that's dogged their application. They've found that the local authority have simply kicked it back, and what they've lost there is not only the money, but also essentially to them time, because they need to get their premises up and running because they've spent a lot out already in trying to obtain the license. So there are many issues that we need to address on the style of management of the premises, depending on whether it's a bar or a restaurant or a club. All run differently, of course. There are other issues to address, such as noise issues, antisocial behaviour from customers, how you're going to deal with that. People tend to get a bit louder when they've had a few to drink in the best run establishments. Your management practices will have to be looked at, public safety, obviously, underage sales policies and so on. So there's quite a bit to consider in preparing that document, and we have the experience that can assist you, I think. Much of what's contained in the schedule can subsequently be turned into conditions on the license. So it's very important to get this right at the outset to avoid the situation arising where, again, as I said earlier, you obtain a premises license, but because of the conditions attached to it, it becomes almost inoperable for you, certainly in terms of perhaps hours and restrained hours, or lesser licensing activities than you particularly wanted. And if you don't have the right conditions also, it can present quite substantial problems going forward with licensing officers of the council who will be seeking to enforce for breach of those conditions. So pretty essential you get that right from the outset. So you need to use professionals, if I may say, specialists in restaurants, bars and club applications, and experts who know the other best experts on noise and antisocial behaviour, crime and disorder, and we can bring those to bear on the application. We have many years of experience and expertise built up in this area, specialists particularly in the hospitality sector, and we know all the various experts we can bring to bear to assist you. So please have regard to that matter, particularly when framing your application. We think it's a very important thing to get right from the outset. So I've spoken for quite a while. I'm going to hand over to Neil now to deal with our next topic, which is on research, I think, Neil.
Yes, thanks, Gareth. So it's very important to do your research from a licensing and planning perspective. And this is regardless of whether you're looking to acquire a site that might already have a premises license if you're looking to vary, or a site that is requiring a new premises license altogether. Or it could be actually that you've got an existing bar and you want to sweat the asset and extend your hours, for example. Now, in terms of doing research, don't do what some people do and say, right, why have I got a 12 o'clock license? The next door bar can serve to 1 o'clock. If they've got it, that's a precedent. It means I will get it. Unfortunately, it doesn't work that way. Any licensing or planning lawyer worth their salt will know how to do the appropriate research. The first thing we do is we actually look for policies, and particularly in respect of licensing. Every council has its own licensing policy that's reviewed every 5 years, or can be reviewed more often. That policy will dictate what they look for in applications, and in particular they might allocate some areas to be what they call cumulative impact zones, and these are areas where it's so densely populated with licensed premises. They say there's so much crime disorder or so much public nuisance, enough is enough, and they say it's their presumption that you have to rebut to refuse all new applications for variations or for new premises licenses. Now, sometimes they cite some examples which would be exceptions to this rule, but they are few and far between, and they're not particularly helpful to the operator of a late license bar, for example. They tend to be if the capacity is fewer than 50, or it's not a drink-led premises, an alcohol-led premises, or it could be that you are only going to vary the license within what they call their core hours. And core hours varies from council area, but they're generally earlier hours than a bar operator or a late night restaurant operator would want, typically 11 or 12 o'clock at night. So don't listen. There'll be lots of people talking in your ear saying, don't worry, I know somebody who managed to get that place a 2 o'clock license, or 3 roads down there's a place that's got a 5 o'clock license. That could be completely immaterial. It could be in a different area of a council policy. So what we do is we study the policies. We also look at recent decisions that the council have taken. It's very interesting to see which way the committees are going, because that does change from time to time. And also, as Gareth mentioned, we know council officers up and down the country, not just in London. And that's great because we're able to actually pick up a phone to them and have a casual chat at the very beginning, before any money has been spent sorting out heads of terms or even engaging lawyers or experts formally. So how we tend to do it, we tend to operate a traffic light system. So if a client is looking to extend their existing license or acquire a new site, we will put together a very brief document, which will be a traffic light system. And at the end, it will say, red, don't touch with the barge pole. You're never going to get this granted. Amber, tricky, but can be done if we do it properly. Or green, should be a straightforward application. So just by way of an example, if you had a new shell in Soho, let's say it was previously residential accommodation being converted, and you had an agent saying to you, you'll be able to get a 2 o'clock license for a bar with vertical drinking and no food, we would actually say, look, I'm sorry, values are red, it's not possible to achieve. However, we could potentially tweak the concept and make it such that it would get through the policy and potentially be accepted by Westminster City Council in this respect. So yeah, please just be careful. There'll be a lot of people telling you things are possible and they're not, but we try and be realistic and actually tell clients at the very beginning what can and can't be done. Anyway, over to you, Gareth.
Thanks, Neil. And leading on, I think, from that is, I think, another topic which I think is quite important, and that's all about understanding the local authority you're dealing with. And we said at the beginning that this application, of course, is going into a local authority, and that means not only officers, technical officers, as we've said above, but also politicians, elected politicians, who also have different views and outlooks about applications going in front of them, which are not necessarily the same as officers who are looking at the technical issues. And very often we will need to understand the political drivers of the people making the decisions on your applications as well. These decision makers in the local authorities on your applications are ultimately the elected politicians, particularly on the major applications, and their role is very important. So you'll find often, leading on from what Neil has said, that certainly in areas where there is, for instance, a cumulative impact policy operating, particularly say in Camden or Westminster City Council, licensing officers there feel obliged to refer matters. Not only feel obliged, actually they're told and instructed that licensing applications in those areas where there are stress area policies, which effectively indicate that no new licenses will be granted or there'll be no extra hours, those applications will have to go in front of elected politicians to decide. So it can often be the case that even where you have no objection from any other source, and I've had this in Camden and Westminster and other authorities, no residents objecting, no environmental health, no licensing officer, you've discussed it all with them and everybody's very happy, no police. The only reason you're going off to a committee is on the basis of the restrictive policy in that area, and the licensing officer feels obliged to put it in front of the members. So we think it's very important on such applications that we try and engage as well politically on the application. And sometimes where residents are involved, it can be intensely political. So we can't speak, obviously, with the politicians who sit on the committees, because that would be unfair. But we can, of course, speak, and we do engage with local councillors, perhaps those in whose ward the application is, in order to get them on board, or if certainly not on board, to ensure that by and large they're happy with the application and can perhaps liaise between ourselves and hostile residents, and sometimes councillors are very useful in that respect. So we speak to those politicians who are not directly connected with the application, and very often it is the case that they will have words with political colleagues as well behind the scenes about applications. We all know what happens, and words will be said and encouragement given to members on a committee. So resolving issues with elected members, particularly councillors in whose ward the premises may be located, will always smooth the passage of any licence application. And recently we've worked on substantial premises licence applications. I'm thinking of one which is the Cocoa Complex in Camden, which is in Camden High Street, slap bang in the middle of their policy area. And we were able to work constructively with ward councillors, elected politicians from a very early stage, to see that we got that right, and we got, as it were, political buy-in. So if that's not addressed at an early stage on a major application, then again, the consequences will be costly failure, sometimes of many millions of pounds on the bigger projects and thousands on the lesser projects, but all considerable loss to you as applicants. And the initial investment is at risk. You've paid out for commercial rents and works, and also the costs of any further appeal to the court, because that will be a costly exercise too, far more costly than the original application was. So I've also been elected councillor myself, and I've chaired both the Planning and Licensing Committee in a London borough, so I know all the political imperatives which are in play here. I've stood for elections on several occasions, some successful, some not so successful, and I think this is quite a unique experience amongst licensing solicitors and barristers to bring to bear on your application. And there are very good barristers and very good solicitors around who will have knowledge of licensing law and procedure, but there are few who have knowledge of the political imperatives in play. And I know also, working closely with Neil, that he regards this as a very important step and is also excellent dealing with councillors from the get-go as well. So please have regard to that matter as well when moving your application forward, and we can always assist in that respect. Neil, do you want to move on to the next one?
Yes, thanks, Gareth. So a little bit about advisors and experts. Now, I'm not talking about your licensing lawyer here. I think you know what we're going to say about that one. I'm talking about the broader team. So firstly, in terms of a property lawyer you use, it's important, this is if you're acquiring a premises, it's important to use a property lawyer that is experienced with licensed units. And we've got a number of those at Keystone, but we work with firms up and down the country with some very good lawyers and some not so good lawyers. And the good lawyers tend to be the ones who have got experience of dealing with licensed premises. And I say that because it's important if a deal is conditional on licensing or planning. So this would be, for example, you're going into a brand new unit and it's going agreement for lease followed by lease. And the signing of a lease is subject to getting a premises license or subject to getting planning permission. Well, it's very important that in the agreement for lease, it just doesn't say that once a premises license is granted, you have to sign a lease, because there's a premises license and a premises license. You could be granted, one with a term now of 9 o'clock with 58 very onerous conditions that would mean that trading is too onerous to be practical. So we actually say that we draft, along with a property lawyer, the agreement for lease that says that you only enter into a lease once you acquire a premises license free of onerous condition. And we would then help the property lawyer draft those onerous conditions, those triggers, which if pulled means that you can walk away from a deal. If it's an existing site, we also like to work with experienced property lawyers, because they will know it's very important just to do, not just do the standard due diligence, but to do licensing due diligence, which often inexperienced property lawyers forget about altogether. And also, I've had some horror stories where the communication's been so poor that the property lawyers have forgotten to tell me they've actually completed, and we need to transfer the license. And it's only when I've chased them a few weeks later saying, what's going on with the deal, has it gone dead? They've actually said, oh, I'm really sorry, actually, we completed 3 weeks ago, so I had a problem. Well, potentially it could have been a problem when the license hadn't actually been transferred. So yeah, very important to get your property lawyer right. Secondly, it's helpful to use an architect that again is dealt with licensed premises as opposed to just hospitality and leisure, because you have to have licensing act compliant plans drawn up, and there are various requirements to what the plans need to show and shouldn't show. And certainly with an experienced architect, they will be able to do those quickly and efficiently, which is very important if time is of the essence. And the final advisor, which we sometimes bring in, is what we call an independent expert. And this is often an ex-environmental health officer or a former police officer who has set themselves up as an independent consultant. And they will be able to give independent evidence to a licensing committee. And I'll give you an example of why this is important. This was just before lockdown. We managed to acquire a standalone bar for late hours in the West End stress area in the city of Westminster. And one of the factors that enabled us to achieve this was we had an ex-police officer who went into the premises as it was operating, which was a requirement to have food with any alcohol. And then we applied for what's called a temporary event notice, which you've probably come across, which is a standalone license, which can ease the conditions of operation, and we applied for temporary event notices to allow the bar on the premises on a couple of nights to operate as a proper bar without any requirement to have food. So he was able to go in undercover, as it were, on both the nights where we're operating as per the existing premises licence, and also the nights we're operating as per this temporary relaxed licence. And he produced a very favourable report, and the committee agreed with what he said, and they granted the application. So yeah, we do have to bring in experts and advisors to assist us, and it's very important that you get the right ones. Anyway, over to you.
Thank you, Neil. Always good advice as well about experts there. Now, the next point I wanted to deal with was, having just dealt with choosing your experts wisely, as Neil has just addressed, is choosing your lawyer carefully, or your advisor on the application carefully, to maximise the continuity of advice and the relationship. Dealing with one person, we found throughout the whole application assists with the procedure, and we've always been alongside our clients from cradle to the grave, if you like, from the beginning, from the conception, the ideas, to the end process, which will usually involve a hearing before the committee and obtaining the license, the satisfactory license at the end of that. And it's very exciting to be with clients, to go to initial site visits and see a building site or a disused premises, and look at their ideas for that site and assist them in obtaining their dream and what they can do, what they can't do realistically as we go along, and then getting the eventual license so that they can operate it successfully and make money at the end of the day. Now, many licensing consultants and licensing solicitors will draft in a licensing barrister during the later stages of an application in order to deal with a hearing, perhaps, or present submissions at a committee hearing. And this, I've found, can often annoy and frustrate clients who have known the lawyer throughout, all the way through the procedure, only to find that there's another lawyer stepping in with extra fees, and they're having to become familiar with the whole case again from the very outset. So that also leads, of course, to a doubling of costs, as you're then required to pay for two sets of lawyers, or consultant and a barrister. And using someone like myself or Neil on these applications, I think is probably essential, because both Neil and I will take the case for you right through the process, right through into court and at hearings. I'm a barrister, many years experience in addressing courts and committees, which is often a key element. If it goes wrong there, we're not going to get what we want. Neil is also a very skilled solicitor advocate and has done his own advocacy for many, many years. So there's that continuity there from both of us, and we think that's very important in terms of going forward with your application. So what you need is continuity. We will be with you from the earliest ideas right through to providing the advocacy in the licensing committees, deciding the application should it get that far. And we've had the advantage, of course, as we've said, of knowing all the officers and the experts throughout, so that when we get to a hearing, we know everyone who's in that committee room. So you won't have to double up on fees by instructing further lawyers to act for you. As I said, I've done this for many years as a barrister. Neil has done it as a solicitor advocate, and we think this is very important in saving you costs and fees as well going forward. I often quote the example. I mean, I've known many very, very good licensing consultants operating in our field, and they are excellent. But from time to time, some licensing consultants get it wrong, and they're not there throughout the whole process. And I've had, for instance, very recently, a major restaurant in Mayfair in the West End, where a licensing consultant was instructed and sadly didn't establish the good relationships with council officers at the beginning, and was not sadly a brilliant advocate when it came to presentation in the committee in front of the members. And according to the client who eventually came to me, it was a complete disaster from beginning to end in terms of both the preparation and the presentation. And on a major investment such as that in a West End major premises, that's a disaster, and a lot of money was lost. And then, of course, one has to pay the extra money on instructing people like Neil and myself to put matters right at the end of the day. So please have extra regard to that matter. And we say, of course, that we will be the right people to take your applications forward in this respect. So an important matter, please have regard to it. Neil, do you want to deal with the issue of timing?
Yes, thanks, Gareth. In terms of the timing to do a substantial variation or apply for a new premises license, I can tell you the statutory timing, and that is that once you make the application, there's a 28-day consultation period. If no representations are received, that's objections, within that time, it's granted a sort on the 29th day. If there are representations which can't be negotiated and are withdrawn, there is then a hearing within 20 working days. So if there's no issues, a month. If there are concerns, 2 months. But that doesn't actually tell the true picture, because you'll have to do other steps potentially. You'll have to get some plans prepared by your architectural designer. That can take some time. It might be, if there's concerned local residents nearby, you might want to have a meeting with them. If it's in a large city that offers a pre-application formal service, you might think it political to engage the services of a licensing officer to sit down and go through the application in advance. So all this can take time. And also, at the moment, we're seeing considerable backlogs with having hearings being heard in the major cities, because that 20 working day deadline to have a hearing can be extended. And certainly in London now, hearings are being shunted back, not just weeks, but potentially months in some circumstances. Also, there's also the risk that you don't really quite get the license you want, or God forbid the license isn't granted at all. And in which stage you either want to reapply, so you're back to square one, or you want to appeal the license that can take many months, if not a year, to reach the magistrates' courts. In other words, don't leave it too late. I think, as Gareth alluded to with that earlier example, many people spend a lot of time going, for example, planning and getting the other permissions in place, and think that licensing is simply a rubber stamping paper exercise. It is definitely not. In terms of what can be done if you are in a fortunate position that you've sent out all marketing materials saying you're opening on a certain date and you don't think you'll get the license in time, it could be that you have an opening date for 1st September, but your hearing's on the 2nd. There are some steps you can do to mitigate the damage if you don't want to put the opening back. You could apply for temporary event notices. These are the temporary permissions I mentioned earlier. You're allowed up to 21 days in any calendar year, albeit between each notice there has to be a 24-hour gap period. So, for example, let's say you're only going to get your license 3 weeks after opening, you hope. It would mean that you'd have to have a gap day every 7 days. So it's not a perfect situation, but it could salvage things. Also, you could open but not carry out licensed activity. So the licensed activity is the sale by retail of alcohol, not the supply. So if you're caught a bit short and your license hopefully will be granted, let's say 2 days after opening, you can always do a soft opening and give away a limited amount of alcohol free of charge whilst charging for the food, provided you don't inflate the price of the food. So yeah, please think about timings at a very early stage, because yeah, the more time you give yourself, there's more time to go back, revisit things, revise the application, and nobody wants a last-minute panic. Over to you, Gareth.
Thanks, Neil, and that's so important. And please do remember, as Neil has alluded to, on licensing, there is a lead-in time of several weeks, and certainly if you're looking to obtain planning permission as well, as my clients were looking to do out in Hampshire, you're looking at a lead-in time of at least 6 months. And I know one is always excited when one takes a lease of a lovely premises and you think it's ideal. And then you look at the planning application, which is going to take at least 6 months to get through. And the licensing application, which is probably a 2-month run-in, a little shorter, but still some considerable period of weeks and discussions. Please do have regard to all of that at the time that you're taking a lease, and it's advisable to build in conditions into the lease agreement about timeframes and so on, and Neil and I are advising on those kind of agreements all the time. Now, the next matter I want to deal with, next slide, is on fees, because many of you will be asking, well, what's it all going to cost? And it's essential that you have control and clarity over your fees from a very early stage. The problems often encountered by operators seeking new licenses or variations is of ever soaring legal fees, which limit the ability to build a budget and can impact on a budget. And there's nothing worse than a lack of knowledge for clients on fees, we found. And those constantly escalating legal fees can really eat into quite substantially into the cost of a project, and you don't want that. Now, if this is not addressed at the outset of a client-lawyer relationship, then it can only cause doubt and uncertainty going forward, and we never want that. And it's because of, I think, this main element that we have excellent relationships with all our clients, because they know what it's going to cost. Solution to this problem in retaining a lawyer on an estimated is to retain a lawyer on an estimated or fixed fee basis, perhaps with an option to review, so that you know the costs will never ever get out of hand. Licensing cases can be costed out through their various phases, including a pre-application phase, which we've talked about earlier, working with officers and politicians, the application phase itself, all of the drafting, the notices. Notices have to be displayed on the premises, and newspaper advertisements. One of my clients, again, very recently put in an application themselves and forgot to put the newspaper advertisement into the local rag. As a result, the local licensing authority kicked that application back, and again, 4 or 5 weeks was lost to the client, which when they could have had a license several weeks before. So very important you remember that, and we deal with all of that in the application phase. There's the consultation phase, of course, the discussions, the negotiations with local residents, officers of the council, police, and so on, and there's a cost to that. And of course, as I said in my last segment, there's the cost of hearings as well. And so we look at all of that when we assess a case at the very outset, and we try and give you the best fee possible. We'll discuss it with you. In most cases, that will be a fixed fee, so you'll have control over budgets, and we will discuss that with you together. Now, we know each and every case obviously is different. We're dealing with these all the time, but we'll put a cost on it at the outset so you can budget. There'll be major multi-million pound cases. They'll obviously be different, but even then we operate transparency so that a scale of fees can be agreed at the outset. You'll avoid the necessity of drafting an external barristers, of course, for hearings, as I said before, as so many solicitors and consultants tend to do, and that will keep costs down for you. So I'm a barrister. I bring all that knowledge and experience to bear in your best interests, as does Neil, as a solicitor advocate of many years' experience. So please have regard to that and that certainty that we will give you going forward on your fees. Neil, do you want to have a look at getting organised?
Yes, thank you. Very important to get organised, and I appreciate it's very difficult to do, especially when you're acquiring a new premises and you're working very long hours under very stressful circumstances. But it really pays to get the paperwork right. Not only does it actually keep fees down, because if it's an hourly rate, less time be spent by the lawyer, or if a fixed fee is agreed and the lawyer knows actually you're a very organised person, and I know I've got a number of clients on this call, I know they're very good, so this is not aimed at them. But if you know you have a very organised client, it won't take you so long, so a fixed fee could potentially be reduced. What I'm talking about is things such as giving instructions. Now, some people try and give their licensing law instructions on a mobile phone on a building site. It's very important. It's very difficult to hear. And the problem with that is it leads to confusion and further questions being asked in the future, or it can lead to mistakes being made. I always like to have instructions in writing. And this is, when I say in writing, during by email. I know WhatsApp is very popular these days, but we have files. It's much easier to have an email file away we can access. Now, if it can't be done in writing, actually a face-to-face meeting where we can actually write it down and confirm to you what those instructions are is very useful indeed. One of the delays that I mentioned earlier, there can be, is getting the plans done. Now, if you can get the plans done in advance, that's very useful. And we have a crib sheet we can hand to people who to give their designers to make sure the plans are up and running at the same time as the licensing lawyer is approached. Things such as the blue notice, we send out the blue notice, and Gareth mentioned this just a few seconds ago. Very important to get that paperwork printed out and put up the next day. If it's not, we can rectify it, but you don't see what happens behind the scenes. It will involve us going to and fro with the council. It will be us amending the blue notice. It will be us going to the publishers of the newspaper in question, having to put the date back potentially, and all that can add to costs. And finally, on paperwork, what I would say is some people try and be helpful and sort of draft the application themselves or part draft. And I don't want to sound rude, but actually that's not very helpful at all, because it takes far less time to actually start from scratch. I mean, we've drafted thousands of applications in our lifetime. We know what works and what doesn't work. I mean, I wouldn't try and take out my own appendix. I'd go to a doctor to do that. I think likewise, whilst it's very good to give proper instructions, I would ask the licensing lawyer, licensing agent, or licensing barrister to do all the drafting of the actual application itself, and within reason, the ancillary documents. I'll give you one example that I had recently. I had to do a hearing instructing late in the day because the application was made by the client. I mean, the client was very good at their job, a very skilled, knowledgeable person, but of course didn't have, and why should they have, knowledge of a licensing process and how it worked. In actual fact, half the hearing I spent was actually trying to explain what was really meant in the application, trying to amend it and unravel the confusion that it caused. So yeah, please get the paperwork to hand, but yeah, it's much cheaper, more efficient, and a better chance of getting a good outcome to let the licensing lawyers actually do the drafting. Thank you.
Thanks, Neil. And our last topic, which I put on here, is to do with planning. What does licensing to do with planning? Well, we think it's essential to ensure that you have a valid planning permission in place before applying for a premises license. Now, it's not determinative of the premises license application if you haven't got the necessary planning in place, because we see that the two regimes, planning and licensing, are quite distinct from each other. But it is important, and it does colour the judgment of officers going forward, even though they say they won't have regard to it. And it makes it a much more comfortable application for people like Neil and myself, because we can always hold up a planning permission, say this premises has permission to operate as, in planning terms, a Class E restaurant, a sui generis bar, and so on. So that assists us in the argument going forward. And I've worked on many of these applications myself over the years, and I've had many clients who've come to me over all these years with great new schemes for the future of their premises, fantastic schemes, and they've spent a lot of money in getting them all ready, and they want to get a premises license, simple as that, which allows them to operate in accordance with their dreams, their business plans, and so on. They've often negotiated a brilliant new lease with the landlord, and that's all in place. We've referred to that earlier. But often the whole enterprise is held up by the fact that there's no valid planning permission in place, and nothing exists that would allow them to use the actual premises as a bar or a restaurant. And sometimes we've gone right through the licensing process to get a good license for someone, only to find that there's no planning permission, and then planning enforcement officers are all over the premises serving notices to stop the operation. So that's crucial. So even though you can have a valid, perfectly valid, stonkingly good premises license, you'll often find that without planning permission, then you're going to be in difficulties in terms of operating. So it's a crucial problem. It needs to be resolved very early on, because it will hold up some premises license applications and thwart others, and also your operation should you get the license. So it's crucial at this stage. I've done many years myself in planning and planning work. I started out in my practice at the bar as a planning lawyer, so I'm aware of all the issues around planning, and I certainly help to resolve those issues from the outset. And if I think something's going to need or require planning permission as well, then we can run a planning application first, or maybe even run a planning application alongside a licensing application. As I said earlier, planning applications, you must remember, take a little bit longer. There are far more policies that come to bear in planning, such as if you're in London, for instance, you have government guidance, National Planning Policy Framework, you'll have a regional policy from the Mayor of London, you'll have the borough policies. For instance, if it's Camden, Westminster, Greenwich, Southwark, they'll all have their separate planning policies, and you'll have local policies which are pertinent to individual areas within boroughs, and even street sensitive policies about what planners prefer to see in terms of a mix of operations in their street, whether they want to see so many bars, so many retail outlets, so many hairdressers or nail shops or whatever in their street. So they want to get a balance too. So all of that needs to be borne in mind in the round when considering the new premises that you've got. We find that many licensing lawyers, consultants simply don't have that experience. They'll also, again, here we go, need to draft in another team of lawyers or consultants to assist, which can involve more cost because the new lawyers, the new consultants have to become familiar with the premises themselves, and you're going through the whole process yet again. And that all takes time, and it's effectively like starting all over again. So from the very outset, I will be involved with the planning as well to ensure that you can operate the building as you want to, even when you've got the license. So please bear that in mind too as a very important factor, and we would urge you to have full consideration to it before you look at a premises and take a lease on it. Come to us for the advice on how to sort all of that out. So I think that those that we think are the 10 most important issues you need to face. There are, as I said at the beginning, others, but we think those are the important ones that you will need to address in going forward with your application. Before I round off, are there any questions and answers to Neil or myself from everyone? I can't see any questions or answers that have come through. Very quiet lot of attendees today. We hope that's been of assistance. Before I just end up, Neil, do you want to say anything about what we've discussed in conclusion?
No, I mean, all I say is if people are just being shy, by all means, pop us an email later on or give us a phone call. We'll be happy to assist. But no, thank you everybody for listening.
And I think that's right, because what we've done is put onto the website a button that you can click to get advice from Neil or myself right up front if you want. And what we do in the firm is set up a consultation. I mean, I call it the pathway and strategy to get your premises license consultation. It's effectively a 30-minute consultation. I can meet any of you, as can Neil, in our offices in central London, or conduct a telecon or a Zoom or Teams conference like we're doing today. I prefer to meet in person if we can, but this is the nature of the beast during COVID. I can even come to your site, and we do site visits, subject to it being within a reasonable distance. So there are a range of options there to suit you that Neil and I offer. And in the initial session, what we tend to do is to run through nearly everything we've discussed today to make sure you're in tickety-boo shape to put in your application. We'll go through your vision for the premises and your proposals together, and at the end we'll have a broad strategy for preparing your application for submission to the local authority, and what will be required to make it a successful one, and importantly and crucially at a cost-effective price for you. So those are our thoughts. We hope our little webinar today has been instructive and given you some guidance, and as Neil said, please feel free to contact us at any time. Our contact details are there on the screen. It's been great chatting with you. I hope that you can take something away from this webinar, and please feel free to get in touch with us at any time before you start your application process. So thank you very much, and goodbye for now.